The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. And welcome as well. We have two cases that will be submitted this morning. Those cases are Weizberg and others versus City of Des Moines and Gasco, USA. The second case is League of United Latin American Citizens of Iowa and Taylor Blair versus Iowa Secretary of State Paul Pate. Those two cases will be submitted on argument, and also submitted is Myron Dennis Baum and others versus City of Cedar Rapids. We'll now hear the arguments in Weizberg. Ms. Mackel, you may proceed.
Good morning. May it please the court? Counsel. I'm Shelley Mackel with the City of Des Moines, and while I acknowledge that the content and order of my argument is at the court's pleasure, it's my intention today to start with a brief statement of the facts and procedural history, and then follow that with argument about procedural due process, which was the subject of the city's appeal, and then, time permitting, I'd like to touch on a couple of the arguments in the plaintiff's appeal, particularly equal protection and the preemption issue. So the City of Des Moines utilizes an automated traffic enforcement program. It's shortened to ATE, and GATSO is the company that contracts with the city to provide equipment and services. And the specific device at the core of today's argument is a fixed camera at on eastbound I-235 at about the 4700 block. And what happens with those cameras is that when someone is speeding, that camera takes a photo, particularly if someone is speeding at 11 miles per hour or more. The camera takes that image of the rear license plate of the vehicle. Then a law enforcement officer reviews those and makes a decision about whether or not the ticket issues. And if that decision is made, then GATSO sends a notice by U.S. mail to the owner of the vehicle. Those notices include details about the violation, and they also advise a person that they are able to contest the violation. And there are several ways at the time of these violations that one could contest. They could go to the district court for a municipal infraction, which starts at the small claims court. They could go to an administrative hearing that the city offered. And if they were satisfied with that, they could stop there. If they were dissatisfied with that, they could go on to the municipal infraction process. And it is undisputed that at the time of these violations, the administrative process was not codified in the city's ordinance. That was an informal process that was not included. The only reference in the ordinance was to the municipal infraction process under the Iowa Code. So each of these plaintiffs received notices of the violation, each of them contested by way of the administrative hearing, and none of them decided to take it further on to district court to challenge the tickets.
Yeah, how do we know that wasn't because of some of the misleading language in the notices? For instance, as you know, when one of these administrative hearing officers came up with a decision, the notice itself says judgment, and it is ordered that a judgment total is due, and so forth and so on. And that's, I mean, it wasn't a judgment of any kind. Then there's an admonition about you may be referred to a collection agency. My heavens, based on this administrative procedure. I mean, the notice, I mean, I could frankly go on and on. These notices the Court of Appeals has recognized were, I think the term they used was misleading. But can you use these kind of notices to convince people, if you will, to pay rather than to go on to a municipal court proceeding, consistent with due process.
Well, I'd like to first differentiate our notices from the notices in Cedar Rapids, which the Court of Appeals already reviewed, because those notices did not mention anything about the ability to go to the district court.
I know, and yours does, kind of, if you read real hard, but when I was in the Attorney General's office in Consumer Protection, we were looking at various notices that a company would put out. The fact that it was buried somewhere, that you had the right of a notice, or, I'm sorry, right to proceed to district court, when there's misleading representations in the body of the notices, would cause real problem. I mean, it's the kind of thing that's kind of designed to mislead people and encourage them to pay rather than to resort to the statutory apparatus. I mean, take me on, of course. I mean, that's why I'm
Well, I
asking
have
you.
to.
Yeah, sure, of course.
I think there's an important difference between the two notices, first of all. I understand what you're saying about the judgment notice. That sounds very much like a court decision.
Threat of collection.
The first notice, however, I would disagree, has that kind of coercive language. It simply says there's an administrative process, you can go to that, or in lieu of that, you can go to district court.
And if you don't go through the administrative process, it'll be deemed an admission?
Yes, if you
Don't go
acquiesce.
through the administrative process, it's an admission? Where'd that come from?
If you don't contest, it's an admission.
Doesn't the notice, if you don't contest in the administrative process, it's an admission? Can that be?
I think it could be. A person is not forced to. It says then also, in lieu of that, you can go to district court. So is the language perfect? I would say no, it is not perfect. And
It is actually failure to pay the penalty or contest liability by the due date is an admission, right? It doesn't say failure to contest as an admission, right?
right, and it doesn't say failure to attend the administrative hearing is an admission. I mean, if people don't pay parking tickets, they admit. But the opportunity to contest was bifurcated into two possibilities, or actually three. You could do both, one, the other, or both. Now, the language in the judgment notice, I do think presents probably a stronger statement than is warranted when it really does amount to a civil penalty, not a judgment. I think that was a misleading statement on the front of the notice.
Nothing enforceable until a district court small claims judge says so.
Exactly. And I agree with that. That is a word that I would not agree is the best option in that situation.
Someone paid up in reliance upon those statements. Would that be a due process problem?
It would if the second page wasn't included, which very clearly states you have a right to appeal this and gives very explicit instructions about how to do that and to get someone into that court process. And the reality is that people do that, so it's not so mystifying that people don't find themselves in the district court process.
Ms. Mackel, let me explore this notice a little bit. Is my understanding that the notice informs the person that they can proceed through this administrative process, get an outcome, and if they aren't satisfied with the outcome, then they appeal? Is that what it says?
Well, it says that they can further contest by requesting a municipal infraction. So it's notice to the city that I want to go further, and we will then file the municipal infraction.
Okay, but there's no requirement to go through the administrative proceeding. In truth, you can just go right into the court.
That's correct.
And is it confusing at all when you first explain this administrative procedure, and then at the end there's just that sentence that says, alternatively, you can file an action in district court?
Well, I don't find that statement confusing.
But it is the confusion that you can request an action following the administrative procedure, or you can request a court action right off the bat. And is it confusing about, well, what are you talking, do I have to go through this administrative procedure first before I get into district court? Or what's this about alternatively, you may request a civil infraction, parentheses, lawsuit in lieu of it? Is that the confusing element of this?
Well, I think that's what the plaintiffs are asserting is part of the confusing element of this. But again, we have people who successfully navigate this regularly.
Well, would have been a lot clearer to just say, you have two ways in which you can challenge this. You can request a civil action in district court, or you can proceed through an administrative hearing.
Sure, I think the wording could have been, and if I could go back and rewrite the notice, I certainly would make it
Well,
easier.
what should we require of government when people are faced with this choice and all they have is this notice to look at? You can't examine the law very carefully to try to sort this out either.
Well, I think, first of all, the ordinance is available to people. I mean, if we provided no instruction about how to contest it.
Yeah, but there's all this language in there about, well, if you don't do anything, then this is an admission of liability and a judgment's going to be entered and you're going to get fines. And I mean, it's just a lot going on here in a couple paragraphs, and it seems like it could have been explained pretty clear to people just what their options are and how you can navigate through the system to resolve your differences in the speeding ticket.
I think the notice probably does suffer from providing a significant amount of information, maybe too much information.
How about wrong information? I mean, there is wrong information in it. There's no judgment after an administrative hearing. There's no, the city's not in a position to get collection hounds on you after an administrative proceeding. Isn't that just wrong?
Well, and I guess I would disagree with that a civil penalty that comes out of the administrative process.
It's not enforceable.
It's not enforceable as a judgment, but it can be collected upon.
I mean, aren't we just talking about it? I mean, if I'm late with my utility bill and they send me a threatening notice and they say you're going to be sent over to collection and we can do all that, that's not a judgment either, right?
Right.
Let's do a thought experiment. Suppose the only thing that was in this notice was the administrative hearing. Would that be sufficient procedural due process, minimally constitutional procedural due process, given we're talking about a $65 speeding ticket?
I think it would satisfy due process. I think that could end up being a preemption problem.
And that's a separate issue.
Right.
But under procedural due process, the fact that there's other stuff going on, I mean, as long as there's nobody could have read this notice and misunderstood that they had an administrative hearing available, right?
I don't believe so.
In fact, all of these plaintiffs availed themselves of the administrative hearing, right?
They did.
And that conforms to procedural due process, minimal procedural due process, right?
I believe so. And
Notice is accurate. There's no due process problem, right?
I believe there's not a procedural due process.
Did any of the plaintiffs contend they were unaware of the option to go directly to court or to appeal from the administrative process to court based on any ambiguity in the notice?
Not based on the notice. My understanding is that some may have gotten some information from GATSO that was confusing, but our argument was in the face of the clear language in the notice, that simply
That's
isn't
it.
reasonable.
I mean, right.
Is this case an appropriate vehicle for class certification? Did the district court abuse its discretion in certifying a class if it's going to depend individual by individual on what they were aware of or understood?
Well, we argued that below, that it wasn't appropriate for class, and it certainly wasn't ripe for a class certification at the time until we knew more about what the actual facts were underlying each of the cases.
Is the intent of this notice to steer people to the administrative proceeding rather than to the court proceeding?
Well, I don't think we have anything in the record about what the intent was, but
Can we say objectively reading this notice, it appears that the city is steering people towards this administrative remedy rather than their remedy in the courts?
I think that the city is making people aware of a proceeding that we believe is helpful and cost-free to an individual. It also weeds people out. If we can't prove our case by a preponderance of the evidence, we have no business going on to a municipal infraction case where there's clear and convincing evidence. We believe that this process is fair and appropriate, and so encouraging people to go through that as opposed to coercing them, I don't think is an inappropriate use of that notice.
But if you have to go to the municipal infraction, the city has to pay the court costs when the filing fees, don't they?
Yes.
So it's an extra cost to the city that they may not recover because they may never, ever get anything from these people, especially the out-of-state people. It seems to me that the subjective intent is to drive these people towards the city's preferred way of adjudicating these infractions.
Well, I think the subjective intent is speculative at best. I would put a more positive spin on that and say we are interested in allowing citizens to voice their complaints as often as possible. We don't want to get into litigation with citizens if we can avoid it. And so I do think it's in the best interest of both citizens and the city to avoid litigation if possible.
Well, correct me if I'm wrong, is the only reference in the notice of violation that one sentence that says on page 2, alternatively, you may request a civil infraction lawsuit in lieu of the hearing? Is that the only reference to this alternative course of action in this whole 2-page notice?
In that notice, that is correct. And then also in the notice after the administrative hearing, there's a paragraph that directs people there. I see that I'm out of time. Thank you very much.
Ms. Mackel, thank you as well. Mr. Larew.
May it please the court, counsel. The factual...
I guess I want to interrupt just for a second, and I'm going to follow up on that. So if that's the only reference that is the only reference I understand in the notice of violation, and then I think counsel just said that there was something in the administrative hearing result that talks about your right to appeal this then to is that right? Is that your understanding as well then? I didn't see anything on your exhibit that was provided to us that says now you can appeal this final administrative decision by means of requesting the city to file this other one.
No, the orders have sometimes 2 pages to them. Any reference to appeal would be on another page. This is the exact form that is issued by GATSO, and it's the one that not only discourages an appeal, in fact, it takes the imprimatur of the Iowa Supreme Court and translates, describing a 2008 decision. I assume they mean the Seymour decision, as bootstrapping the legitimacy for this decision, trying to make this as final. There'd be no reason to challenge this regime if a layperson were to read this.
So there is a second page to this which provides...
If I don't want to misstate it, I think there is, and I don't remember what the advice is on that page, but it would be in the appendix. That's right out of the appendix.
I think it's the next page of the appendix, and it has a provision with a in all caps, right of appeal. If you want to appeal the hearing officer's decision within 10 days of the date of the ruling, you may request the civil infraction parent lawsuit, closed parent, be filed against you in Polk County District Court, et cetera, et cetera. So it's right on the next page.
All right.
Is that misleading?
It is, because
Why?
You have to start with the premise, what is this proceeding? The Iowa legislature defines the parameters of municipal law, and it states that a violation of municipal ordinance is a municipal infraction if it's done civilly or criminally. And it sets out the bare minimum of due process of what's required in municipal infraction. It
Let's
doesn't...
focus on the notice, though. So you get this notice, and I think the undisputed facts are the city has conceded there's some language that, in retrospect, they wouldn't use. On the other hand, you have to concede that the second page of the notice, at least, does state that you can go to district court. Assuming we found this entire package to be troublesome and maybe even a violation of procedural due process, is there any evidence to the record that your clients relied on the misstatement to their detriment?
Oh, absolutely, because this is just what gets the process started. If one wants to engage the system, one calls the number that is listed on the notice, and one engages in a dialogue with GATSO employees who guide them.
Let me come back at you
Yes.
and let me be clearer.
Yes.
Okay, so page 2 states what it states, or, you know, about you do have a district court option, I guess. It states what it states. If your clients were aware of that, I mean, this is hypothetical now, if they were aware of that, wouldn't the problems in the notice be eviscerated because they were aware that they had the right to head off to a district court, and then they wouldn't have been harmed by our editing of the notice?
I don't think so. I don't think that under the minimum due process established by the General Assembly, that cities are allowed to force and shunt individuals to some lesser form where the probability of error is higher.
I think that, I may even accept that premise, but what evidence is there that your clients relied on the misrepresentations to their detriment? I mean, isn't that an individualized fact showing? Someone who says, well, I got this notice, and I knew all this stuff was goofy on it. Judgment, this is no judgment. I mean, you know, supposing one of us got a notice, and we knew, supposing you got a notice, and you would have known that there, you know, kind of various statements about judgments and enforceability and admissions and so forth that are quite right, but you, Mr. Larew, don't mean to personalize it, but I mean, someone with your knowledge would have known that you had the option of going to district court. Can you make a claim challenging misrepresentations in the notice when they weren't material to any action or detriment?
Well, there's no fact in this case that would cause one to conclude that, in fact, one was forced to go to an administrative proceeding, that even the district court option was available. That is, the record of the case was, and it wasn't disputed on a summary judgment motion, no counter facts to the court's conclusion that this was, in fact, a mandatory proceeding. Because as one is a party to the original notice, this of course, is a judgment after a proceeding that has been held in front of the administrative body, it calls itself. The original notice, called a notice of violation, instructs the recipient as to where to go if one wants to contest. That's a number that you call, and the dialogue that GATSO provides its employee directs people to go to the administrative process. It's not, do you want to go to administrative proceeding? Do you want to go to a court? They are told you're to set this up.
Isn't that a preemption argument and not a due process argument?
Well, I don't think it's an either or. They're very closely. The Hancock decision appears to suggest that the failure of the city to abide by its own internal ordinance is a violation.
Oh, but wait a minute, that can't be quite right. I mean, I've read the Hancock case, but we have violations. I mean, we deal with statutory violations all the time, of course. And, you know, we make the judgment call, statute was violated or wasn't violated. But the mere fact that there was a violation of a statute doesn't per se give rise to a due process claim if the underlying process was adequate and fundamentally fair. I mean, a statute can have procedures far in excess of due process. I mean, I could say on this little, and I shouldn't say it little because it kind of accumulates, but on a relatively small amount, I could build in 5 levels of appeal, let's just say. Now, and if I don't give you, I have mandatory 5 levels of appeal, but I skip over the 4th level. Have I violated the statute? Yep. Do I have a due process problem? Nope. And you see where I'm headed? I mean, the mere fact of a statutory violation isn't the focus. The real focus is, was the procedure offered fundamentally fair?
Agree with that, but how does one, by what objective measure does one use to determine the fairness? We have a few examples of where elected officials have made a determination, and one presumes they have given this some thought. So start with the ordinance itself. The ordinance itself is written in such a way there is no administrative process. It says a person goes right to the court, and presumably they knew what they were doing and they relied on.
Mr. Larew, I've read your brief. You raise a preemption claim based on state law. That
Yes.
state law
Yes.
preempts what the city of Des Moines did. Have
That's
you
right.
raised a preemption claim that the city of Des Moines is not complying with its own ordinance?
Right.
Have you raised such a claim?
We have. We said, first of all, and I think the court said, and held in the narrowest possible terms, it was concerned that the city itself was not following its own ordinance. It wasn't going initially, and the word shall as to how that should be resolved under its own ordinance. Secondly, we argued, as a preemption argument, that the guidance that I think the city council was taking when it legislated the ordinance was they looked at 36422 and said, how do we put together minimal due process in order to prosecute in a civil way a municipal infraction? That's the frame of reference that they had. And the statute, or the ordinance, complied with the statute for the most part. So we say there's also, if it's not just preempted by its own language, how did they invent this sideshow? This sideshow where virtually all people were shunted.
Well, supposing we did this, I mean, I understand what 36422 says. You enforce a municipal infraction by filing an action in small claims court. I understand that's your argument. But suppose I say, well, I'm going to pass an ordinance that protects that right, but has a voluntary option. And the voluntary option is, come on down, talk about it. And maybe we can wash this thing out. Tell us what you're thinking, and we're reasonable people, or ... Would that kind of process, put it in the ordinance in nice flowery language, would that kind of process be preempted by 36422?
I think it depends how it's framed with a little more definition. That is, if it provided for an informal dispute resolution at low cost to both parties, fine. If it delegates in that process, not defined by any law, that person then is issuing orders and judgments and threats of collection and imbuing this person with powers that are really invented, I think that's a problem. And I don't know where you would cut that off. Why not take other kinds of civil infractions or criminal penalties and say, okay, we're going to define a little process here. Informally, we'll have these people establish judgments. It's almost impossible to say from what authority does this proceeding derive its ability to issue orders, to name its judgments if having the imprimatur of the Iowa Supreme Court, daring people to challenge it. From what authority is that created? If it were created by ordinance, at least you'd have a basis to say, well, there was a legislative decision that this is how we're going to treat these problems. You could divine what the purpose was. Here we're inventing it. What is the purpose here? How do we measure the effect of the proceedings against the established purpose? What we think is that the city, having invented a municipal infraction process by ordinance consistent with Iowa law, found it to be inconvenient, found due process to be too expensive, wanted to have a high-velocity prosecution system, which was inconsistent with the General Assembly's determination.
Counsel, the Eighth Circuit and the Iowa Court of Appeals found the Cedar Rapids procedure to be optional and therefore not a due process violation. It was just an option. Why shouldn't we follow those decisions?
Well, the federal courts did not weigh in on Iowa law. They said as a matter of federal due process, nothing was violated. That is to say that the federal courts did. We think that the Iowa law establishes a more substantive and a higher standard. We don't find authority for cities under the Home Rule statute simply to make up processes to prosecute municipal infractions that within the authority they can do consistent with Iowa law. That's what's so troubling here in Des Moines, is that they knew what they were doing when they set it up and then chose not to follow it. And I think they found it just to be too costly for their own purpose, which is generating revenue.
But if the citizen's forced to go to court to contest, that's an extra $85 in costs. It's more than double the ticket.
Well,
are you doing a disservice to all the people who want to contest by eliminating this administrative option?
If citizens subject to high-velocity prosecutions were in effect made to pay the cost of real prosecutions of municipal infractions, and they were to find in the process that semi-trucks were exempted, government employees were exempted, I think you'd have a political reaction that the city is concerned about. I think this is a political safety valve. It's a way of dissipating political energy and managing a problem in order to raise revenue. The answer is yes. It's costly to have a system of municipal infraction enforcement that fully protects the rights of citizens. And if citizens aren't willing to pay for that, they have a way of expressing themselves politically, except, and here's the kicker, the way these are set up on interstate highways, most of the people who get the tickets don't reside in the local community. They have no way of expressing themselves politically to make that change. The answer is yes. I think citizens would object to a system that actually reflected the cost of protecting their due process
I
rights.
have a question about remedy. The city argued and the district court found that if they have not paid a ticket, they do not have a claim for unjust enrichment. And yet, the one member or the plaintiff that did pay, the city argues, aha, they voluntarily paid, they can't recover. Can the city have it both ways?
No. First, I don't think Iowa has ever recognized the voluntary payment doctrine, which makes us distinguishable from other cases who make contrary findings. Two, in the course of this proceeding, this court has made a significant decision in terms of the ability to obtain money damages for the violation of constitutional rights, the Godfrey case. It hasn't yet decided, as far as I can tell, that it applies to municipal governments. But when we pled this case, we felt not only do we have a claim, but how do we have a remedy? And we felt the unjust enrichment doctrine was one that we could use. But I appreciate the conundrum that you described, and I don't think that the city can have it both ways.
But you have to prove a constitutional you have to prove a constitutional violation. And is it unconstitutional to exempt trucks that or semi-trucks that don't have rear license plates?
Yes, it is.
But if you go with a front plate, then there are 19 states that don't have require front license plates. Aren't you going to be way under-inclusive if you go that route? And if you have to take pictures of front and back, isn't it going to cost a lot more?
Well, I think you have to measure under Iowa law and equal protection, measure the classification against the purpose of the law. And if we find GATSO seldom describes the purpose of the law, the city is sometimes describes a safety concern. Hard to believe how you would classify and exempt semi-trucks operating on the public highways and exempting them from a statute that was, or ordinance that was truly designed to enhance traffic safety. That would defy the experience of most people who operate vehicles on our highways and experience the potential dangers of the big rigs as they move along. Am I done with my time?
You are.
Your Honor, I am sorry if I exceeded it. Thank you.
Mr. Larew, thank you as well. Ms. Mackel, you're going to split your time on rebuttal?
Yes.
Okay.
I only want to address the equal protection issue that was just discussed. In the record, there's virtually no actual data about how many of these semi-trucks or state vehicles are out there. And it is the plaintiff's burden to demonstrate.
Oh, but it's a motion to dismiss. I mean, it's a motion to dismiss. And ordinarily, I mean, you know, we've got a long string of cases saying that motions to dismiss should be granted only in most extraordinary circumstance. And we don't, I mean, ordinarily, we don't have data and facts. And, you know, you asserted below that this was a cost-effective means of enforcement. You didn't present any data to support that. You weren't required to. And I mean, the motion to dismiss wouldn't be expected to have a bunch of affidavits attached.
Right.
But given the fact that he's challenging the classification as not comporting with equal protection, I know there's a dispute on the level of scrutiny and so forth and so on, but he's saying there's a classification. There is a classification in impact, at least. Isn't it a question of fact as to whether the asserted justification of the city, it's cost justified? Isn't that something that needs to be proved after discovery? And then, you know, you'd have an opportunity for a motion for summary judgment based on undisputed facts.
Potentially, but even with a motion to dismiss, citations can be made to basically available, you know, kinds of data that's out there, and that kind of data is available.
Well, wait a minute. Supposing, let me ask you this is a hypothetical, you'll quickly see, but supposing the city, there's a memorandum in your file, and the memorandum says, you know, there's a question of whether we should include trucks or not. Here's the cost analysis that we've done, and in fact, if we include trucks, the revenue will far exceed the extra cost of the system. And then there's a paragraph that says, but trucking companies are politically powerful and we don't want to bring them within the scope of our ordinance because there will be heck to pay. Now, I'm not saying such a memo exists, but is not the plaintiff entitled to attempt to show that the cost-effective in fact, was not the cause of this classification?
Well, I think that would be correct if we had anything other than mere speculation.
We have nothing at this stage. I mean, I agree with you completely. I mean, this is just the pleading stage, and let's make it very clear, and I make it very clear to Mr. Larew, I have no factual information of any kind suggesting that my hypothetical was what, the record would show if you engaged in discovery.
Right.
But I guess my point is that a plaintiff is ordinarily entitled to an opportunity to demonstrate that a legitimate government interest is in fact pretextual, and that didn't occur here.
I think that's potentially I would agree with you, except that in the record we actually do have some information, even though that part was dismissed on the motion to dismiss. In the record at App at page 189, the DOT says that approximately 120,000 vehicles every day at that particular spot. And then on page 42, the DOT director says there is a low percentage of truck traffic.
Aren't you changing a motion to dismiss to a motion for summary judgment? I mean, under a motion to dismiss, you take all well-pleaded facts as being true. Now you're bringing out outside affidavits and outside things. So aren't you trying to change this into a motion for summary judgment?
Well, I don't think one gets the benefit of well-pleaded facts if you don't know where they came from.
Ms. Mackel, here's one way of looking at it, in my view, and that is you've made an argument that there is a justification for the classification, and the justification is the greater cost of having to photograph both front and back. As I understand the other side, they don't contest that. They haven't contested that today. They didn't contest it in their briefing. Whether they have evidence or they don't even raise argument on that. And isn't that enough to demonstrate that it's constitutional under a rational basis test?
I believe it is, in that they don't, it's not enough to sort of cast doubt on or kind of throw shade
at a minimum, they have to argue that your justification is a pretext, which they haven't done.
Correct. What they do is point to the contract between the city and GATSO that contemplates 4 cameras and says that, well, they're responsible for the cost of the equipment. That's accurate. There's no evidence in the record to demonstrate if we were thinking about different cameras, more cameras, that cost wouldn't be greater. I'm going to turn the rest of my time over to Mr. Burns.
Ms. Mackel, thank you. Mr. Burns, you'll have 3 minutes, and you get the last word.
May it please the court, my name's Paul Burns. I'm here on behalf of Appellees GATSO USA. I previously addressed this court in the companion BEM case, sort of laid out GATSO's role here. I'm not going to retread over the arguments I made in that case. Just briefly, though, I think it is important to keep in mind what GATSO's role is in this case. The primary claim against GATSO, substantive claim, is that the city unlawfully delegated powers to GATSO. And I've discussed this, but I think it's important to keep in mind that GATSO really didn't have any discretion or judgment in this case. They installed the equipment. They installed the equipment where the city wanted it. The city had control over where the cameras went. The city had control over whether there were front cameras or rear cameras. And once the equipment's installed, they review these events that get generated. If they can identify license plate and track it down, they flag it. If they can't, they flag it a different code. All events can be reviewed by the City of Des Moines Police, and no citations get issued unless a police officer.
Who maintains the equipment?
Well, GATSO, well, to the extent there's any maintenance, it would be GATSO.
Certifies that the radar gun is accurate.
Well, there's not a radar gun.
Or whatever, the speed measuring device is accurate.
Well, it gets calibrated in a number of different ways. I mean, the GATSO, the cameras are in essence somewhat self-calibrating, because if the cameras detect any oddities in the system, then the cameras don't take a snapshot, number one. Number two, GATSO comes out at least once a year and runs some other tests with other equipment not manufactured by the same people that manufacture the radar units in the cameras. In addition to that, the City of Des Moines Police Department does their own calibration by driving through the cameras with their own separate radar units to do a check. They drive through, if they register 65, they double check and see what Gatso's cameras registered. So it gets verified in a couple of different ways. So all the courts that have looked at this have found that these kind of private contractors running these systems, I haven't found one that found that there was an unlawful delegation. With respect to the core remedy claim, I think it's this unjust enrichment claim against Gatso. I think it was properly dismissed, and it was dismissed on summary judgment in Gatso's case. You have to have an underlying claim. There is no underlying claim against Gatso. These are constitutional claims. Gatso's a private actor. Gatso did not violate anybody's constitutional rights.
I suspect that Gatso wrote the notices. Is there any evidence in the record on that?
I don't think there's any evidence in the record as to who wrote them, but I think you can read the contract and understand the relationship here that really nothing was going to happen with this system that the City of Des Moines disapproves of.
I guess my question is this: supposing, and this is one of my hypotheticals again, supposing we found that the notice was improper, and that the plaintiff were entitled to relief of some kind based on the improper notice, wouldn't that drag Gatso right into the thick of it?
I don't think so, unless there was evidence that somehow the city ceded its power to Gatso to write that, and then Gatso, if the city objected to the notice and Gatso insisted that they keep the notice, I just don't see how that would work. There is no evidence of that, but you still have to show state action, and there's no showing of that in this case. The discretion and judgment were the city's. Gatso was essentially, administrative.
Does Gatso get a percentage of the citation revenue?
They do. They get I think it's $27 per paid citation. And with respect to the unjust enrichment claim, there were two plaintiffs in the case when Gatso filed a summary judgment motion, neither one of whom had paid. And so I think the court, Judge McClellan, granted summary judgment on that claim based on the fact that there's no enrichment. Neither one of them had paid the fine. After Gatso was dismissed, a third plaintiff was added who had paid his fine, but that claim doesn't hold against Gatso. We weren't in the case at the time. So for all those reasons, I would ask the court to affirm the summary judgment grant of Gatso.
Thank you, Mr. Burns. The case of Weizberg versus City of Des Moines is now then submitted to the court, and we'll next hear arguments in League of United Latin American Citizens versus Secretary of State Paul Pate.